back to Judge Bailey's decision, which I don't know if maybe gut is too strong. Harvey Payton said gut is too strong, but it certainly has the effect of nullifying the state's right to work law. Joining us to talk about that is Elbert Lin. Elbert Lin is the former Solicitor General for the state of West Virginia and author of the brief that West Virginia filed in the Supreme Court of Appeals challenging Judge Bailey's earlier ruling on this. Elbert has since left the state. He's now in private practice over in the mothership over in Virginia. Elbert, good morning. How you been?
Good, Hoppy. Thanks for having me on. And please pardon my voice. I seem to have woken up with a frog in my throat.
You're fine. You're fine. I'm glad you're with us. So did Judge Bailey get it right or get it wrong?
Well, I think the way to look at this is, as you just mentioned, Judge Bailey previously issued an order enjoining the right to work law that went up to the West Virginia Supreme Court, and the court overturned that injunction. And in overturning it, it provided reasons in a 16 or so page opinion, and the main reason was that these arguments that she was considering were not likely to succeed on the merits. So what you have from Judge Bailey is, in my view, an opinion that flies in the face of what the Supreme Court said previously, in an opinion that is, though there have been personnel changes at the court, it's an opinion that is controlling precedent. Nothing has changed since that opinion came down. No new facts were entered into the record. No new legal developments in West Virginia or across the country that would have called into question that ruling. And in fact, the two new legal developments would support what the Supreme Court previously said. Kentucky upheld its right to work law, and the Supreme Court of the United States issued the Janus decision, which I can talk about more.
Well, let's touch on Janus, because that is a U.S. Supreme Court decision a lot of people refer to, 5-4. What Harvey Payton pointed out was, well, that involved public employees. That's a different scenario than the private sector. Does Janus apply here, and if so, why?
Well, I think it's fair to say that Janus does not directly control, because it was about public employee unions, but the reasoning in that opinion is, I think, both telling and persuasive. I mean, the first thing is that the court found that it is a violation of a public employee's First Amendment right to force a public employee to pay an agency fee. So you can't make somebody subsidize speech that they don't agree with. And so to the extent that Judge Bailey is talking about the First Amendment in her opinion, you have the Supreme Court saying that those First Amendment concerns cut in favor of the employees. And then secondly, she has a discussion about takings, which is the idea that the government is taking from you some property of yours without compensation. And the Supreme Court, Justice Alito's analysis, has an extensive discussion about the benefits that unions get from being the exclusive bargaining agent, even without agency fees.
Elbert Lin is with us, former Solicitor General for West Virginia, author of the brief West Virginia filed in the Supreme Court of Appeals in challenging Judge Bailey's earlier ruling in this case. And Judge Bailey has come out with an opinion after a long time. It's been like 2 years or something, by the way, what would be your, objectively, Elbert, what would be your terminology? Does it gut? Does it nullify? Does it tweak the right to work law in West Virginia? What would be your, just objectively, how would you identify it?
Well, I think if it were to stand, it would be a pretty significant change to the right to work law, because it does take out the provision that prohibits unions to negotiate compelled agency fees. And I think that is a pretty significant portion of the right to work law. I don't know that I would use, I find words, as you probably do, Hoppy, words like gut to be a little bit pejorative, but I do think it would affect a pretty big change.
Okay. The argument that is put forth, and I think it's in the opinion, and this is kind of the constant argument, is that, look, if you're going to represent the workers, then there is an obligation, and I think you touched on this with the taking. If you're going to represent the workers, then the workers are obliged, if you will, to provide some compensation for that representation. Again, I'm dealing with that in lay terms. And am I correct that that is their argument? And then, if so, what's wrong with that argument, in your opinion?
Sure. You're right. I think that's the basic argument in broad strokes. There's a couple issues with that, and one of them we explained in the brief that we filed a couple years ago, and that's that you have to understand the framework, the federal framework that governs here. The federal framework that governs has always made it clear that states could enact a right-to-work law of this kind. And so unions entered into the situation eyes wide open, knowing that there was the potential for the law to change beneath them. And secondly, as I said, if you look at the Janus opinion, Justice Alito's opinion, I think, provides a very nice explanation that dovetails with a lot of what we said about the benefits that unions have from being the exclusive representative. And furthermore, that there are other ways to address some of the concerns they have, for instance, representation in grievance hearings, without forcing employees to pay in agency fees that cover a lot more than that.
Elbert, I thought too that, and help me with this, that I thought that, as you have pointed out, that there is a tremendous advantage if a union is going to be the exclusive bargaining agent for the workforce at a workplace. And that the trade-off, as you said, is you have to represent everybody. Is that trade-off, is that codified, is that in code, is that the NLRB, is that a court decision? How is that codified?
That trade-off is in federal law, and that's what I was talking about. There's the underlying this entire challenge, and that's one of the fallacies of the case, is they're challenging the state law and contending that it does a lot of unconstitutional things to the unions, but where all that stuff comes from is federal law. And their real problem with is the scheme that federal law sets up, and it does require unions, if they want the advantage of being the exclusive bargaining agent, that there are some costs that come with that. And it's just a classic cost-benefit trade-off. This is not a one-sided regime, as they suggest.
Elbert, also, you said one issue with the decision was that Judge Bailey's, and give me the language here, where you said there's not that she says, well, it's rational to believe, or what was your point there, which
Sure.
you said undermined her argument?
Yeah, well, I think it's and it gets to a sort of a larger point, reaction that I have to this opinion. So there were actually three constitutional arguments raised, one grounded in the First Amendment, one grounded in the Fifth Amendment takings provision, and one grounded in the idea of due process. And under the law, a statute can violate due process if it's not justified by a rational basis. So any reason, doesn't have to be one articulated by the legislature. Mm-hmm. And Judge Bailey, she ruled in the union's favor on all three arguments, the First Amendment one, the takings one, and the due process argument. And here's the thing for your listeners who are not lawyers. Rational basis review is an extremely low bar for a legislature to meet, because, again, it just has to be any conceivable, plausible reason for the law. And whether you agree with the right to work law or not, I find it very difficult to imagine that to believe that there isn't a rational reason for the law. And the idea that she went that far, and furthermore, I think if you look at some of the footnotes, it suggests that she took the Supreme Court's previous opinion personally. It makes it hard to take this opinion seriously as a piece of legal reasoning.
Elbert, finally, in your opinion, what are the chances that this opinion by Judge Bailey will be overturned by the state Supreme Court, or that it will it hold up? Will it fail?
Well, I wouldn't be a lawyer worth my salt if I were willing to give you a definite percentage. But what I will tell you is it should be overturned, I think, in light of the previous decision of the Supreme Court that, again, concluded that these arguments were not likely to succeed on the merits. And also, I think, a fair look at the federal scheme that underlies, the way unions work, and the fact that no other right-to-work law has been struck down across the country the court should overturn it.
Okay. So that has been the pattern across the country, that right-to-work laws have been upheld at state and federal level? Certainly there have been some exceptions to that.
I am not aware of an opinion that stands where a right-to-work law has been struck down. Some have been struck down, but on appeal, those opinions have been overturned.
Elbert Lin, former Solicitor General for the state of West Virginia, he was involved in crafting the state's position in the right-to-work legal argument. Elbert, it's good to talk to you again. Thank you for coming on.
Thanks, Hoppy. It's always good to be here.
All right. Thank